This is a lecture about ABA Model Rule 1.14. We're going to be talking about representing clients with diminished capacity. Rule 1.14a says, when a client's capacity to make adequately considered decisions in connection with a representation is diminished, either because of minority or mental impairment or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. Let's pause here for a moment. You know what our concern is? Our concern is that when you're representing a client who's mentally impaired or maybe not completely lucid, it could also be a young child or an elderly person who gets confused easily. It's very, very tempting for you as a lawyer to leave them out of the loop and just start making all the decisions yourself. Maybe you feel it takes too long to explain things to them, and you may tell yourself it doesn't do any good to explain things over and over because they don't understand. Nevertheless, as much as possible, you need to maintain a normal client-lawyer relationship with the client. And also, as you're going to see, we certainly want lawyers to be respectful and courteous to people who are marginalized by our society, sometimes because of their impairment or cognitive decline. So let's move on to the next section. Rule 1.14b sets forth some permissible actions for lawyers. B, when a lawyer reasonably believes that the client has diminished capacity or is at risk of substantial physical, financial, or other harm, unless action is taken and cannot adequately act in the client's own interests, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, even seeking the appointment of a guardian ad litem, a conservator, or a guardian. So this is a drastic scenario. You have a client with a severe mental impairment or who is underage, and you actually need to seek an intervention. You might need to have a guardian ad litem appointed, or even a regular legal guardian who can control their finances. This could be someone who helps them make decisions about whether to be hospitalized or institutionalized, or things like that. If so, you're going to have to reveal some information about that, and this rule authorizes you to make the necessary disclosures to protect such a client from themselves, in a sense. Of course, more often it'll be something much less drastic, like notifying the family that they need to get involved. Perhaps this person should not be living by himself or herself, or something like that, and you think the family should intervene to the extent that they can. Section C is about maintaining confidentiality as much as possible when you take these types of protective measures. So, see, when taking protective action pursuant to paragraph B, the lawyer is impliedly authorized under Rule 1.6a to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. In other words, this rule does not give you a license to gossip about your client or complain about everything they've done that frustrated you. You are authorized to make disclosures to divulge information necessary to protect your client's interests, but it does not erase all your duties to protect the client's privacy as much as possible. By the way, I'll be a little surprised if you have a question about this rule on the MPRE, although it is fair game for the test. And the same is true for my own exam in my law school course. Now let's turn to the ABA's comments about Rule 1.14. The first comment acknowledges that when the client is a minor or suffers from diminished mental capacity, it may not always be possible to maintain a normal client-lawyer relationship. And a severely incapacitated person, such as a young child or an infant, may have no power to make legally binding decisions. So imagine, let's say, that you're representing someone who's in a coma or is not lucid enough to recognize anyone. How can they make a legally binding decision? Now it continues and says, on the other hand, children as young as 5 or 6 years of age, and certainly those who are 10 or 12, are regarded as having opinions that are entitled to some weight in legal proceedings about their custody, let's say in a custody dispute. And so is that child old enough to sign a legally binding contract? No, but we do take their opinion seriously about which parent they would want to live with. It goes on and talks about those of advanced age may be quite capable of handling routine financial matters, but they need special legal protection concerning major transactions. So most of us have some elderly relatives who can manage some of their personal affairs. They can go and get their prescriptions filled and stop and get some groceries or stop for a cup of coffee somewhere. They may really cherish the limited independence that they still have, whatever that is, of being able to balance their checkbook or make payments for some of the bills and live sort of independently. On the other hand, we all know that scams and con artists and so forth will often prey upon our senior citizens and our elderly to try to get them to make major financial commitments like a timeshare in Cancun or to put another roof on their house when they just put one on last year. Things like that. And that can be devastating financially. So the ABA rule is trying to recognize that. So I also want to say something to students in common parlance in our society. Sometimes in our legal discourse, we have this unfortunate tendency to categorize people is either completely lucid and sane and functioning cognitively, or they get dismissed as crazy and incompetent or feeble-minded or things like that. That doesn't reflect reality. This does not reflect the consensus of mental health profession right now. There are many, many people who have some impairments or limitations, but are actually otherwise able to function as adults in our society. I confess I cringe sometimes when I hear even lawyers or other academics talk about what we need to do. We need to do this or that with all the crazy people or something like that. It's not a medical term. And if you find yourself thinking your client that way as a lawyer, thinking they're just crazy, then you are the one with the problem. You need to hit the pause button and step back and say, look, my client has a problem with this. My client has some limitations. My client struggles with this specific thing. On the other hand, my client is able to do this and this and this. My client can carry on a conversation, or they have thoughts and feelings. They value their independence, and that's important. And that's what they deserve from you as their advocate. So don't forget that when you're in practice. Comment 2 cautions us that the fact that a client suffers a disability does not diminish the lawyer's obligation to treat the client with attention and respect. Even for those who have a legal representative, the lawyer should try as far as possible to accord the represented person the status of a client, especially in maintaining communication. So this could be an older person who's starting to have some senior dementia or forget things. It could be a younger individual who's clinically depressed or has a brain injury or something like that. Sometimes they can feel confused or forgetful or have trouble focusing. Whatever it is, I can tell you, when you're in that situation, you start to feel like the people around you, the people in your life that you depend on, are starting to make decisions about you and without bringing you into the loop about what's happening. And that can be terrifying. And you can feel helpless, like you're being kept out of the loop about what's going to happen to you from then on, or about what you're going to get to do or not do, or where you're going to live. When your friends and family members or the people helping take care of you or look after you are having these conversations and you're not in the room, it's very, very difficult and stressful. And it's hard if you haven't experienced that or had someone you love experience that. It can be hard to empathize. But it's even worse when it's your lawyer who starts making decisions and having conversations with people around you, and they're leaving you out of it or keeping you out of the loop. You don't really feel like you know what's going on. And that's a big part of what we're talking about with Rule 1.14. I would really encourage you, my students, to read through all the comments and really think about it and try to put yourself in that situation. Not just a lawyer, but also what it's like to be a client in that situation. Now, a client in this situation may wish to have family members participate in discussions with the lawyer. When it's necessary to assist in the representation, the presence of such people does not usually affect attorney-client privilege, just like if you needed an interpreter to meet with your lawyer. Even so, no matter what happens, keep the client's interests foremost. You should primarily look to the client, not to family members, to make decisions on the client's behalf, except for when you have to take protective action authorized under paragraph B. If a legal representative has already been appointed for the client, the lawyer should ordinarily look to the representative for decisions on behalf of the client. Now, it can be challenging for a lawyer in this situation to keep reminding the family that the lawyer is representing the client with the mental impairment and not the family. A lot of times, honestly, the family is paying the lawyer's fees, and so they feel like the lawyer should do what they want. Keep in mind who your client is. Comment 4 to this rule says, in matters involving a minor, whether the lawyer should look to the parents as natural guardians may depend on the type of proceeding or matter in which the lawyer is representing the minor. If the lawyer represents the guardian as distinct from the ward and is aware the guardian is acting adversely to the ward's interests, the lawyer may have an obligation to prevent or rectify the guardian's misconduct. That's fairly clear, I think, so let's move on. Comment 5 reminds us that Rule 1.4b allows protective measures when necessary, and it gives an example. A client is at risk of substantial physical or financial or other harm, and remember it says a normal client-lawyer relationship is not possible due to their incapacity. So when a lawyer needs to take protective action for a client, what are we talking about with measures? Well, it could include just consulting with the family members, or maybe a waiting period to allow a situation to improve or become clearer, a voluntary surrogate decision-making like durable powers of attorney. Could include consulting with support groups or professional services or adult protective agencies and social workers. Comment 7 says, if a legal representative has not been appointed, the lawyer should consider whether appointment of a guardian ad litem or a conservator or guardian is necessary to protect the client's interests. So thus, if a client with diminished capacity has substantial property, let's say, that should be sold for the client's benefit, effective completion of the transaction may require appointment of a legal representative. In addition, rules in litigation sometimes provide that minors or persons with diminished capacity must be represented by a guardian or next friend if they do not have a general guardian. Sometimes appointing a legal representative may be more expensive or traumatic for the client than circumstances require, so it shouldn't be like your first recourse or the first thing you do. Comment 8 reminds us that there will be consequences when we make disclosures about our clients. Disclosure of a client's diminished capacity could adversely affect the client's interests. And so, for example, it can lead to involuntary commitment or institutionalization against their will in extreme cases. Information is usually protected by Rule 1.6. That's our duty of confidentiality. So unless authorized to do so, the lawyer can't disclose such information. And that concludes our brief overview of Model Rule 1.14.